not an extreme risk, I don't want them to lose their weapon. But if someone is an extreme risk, I don't want us to do nothing and allow a knowable fatality to happen. And we've investigated this in our office in the context of domestic violence. 60% of people who die in domestic violence are situations that are knowable, and it's because of a firearm. And suicide is actually also really common here, so I shouldn't only talk about homicide. In fact, more likely than not, we're saving lives from suicide than from homicide. Yes?
On the same subject, the verbiage in the ERPO bill does not call it an extreme risk. It calls it a significant risk. And there's a big difference. Why aren't they calling it an extreme risk in the bill?
It's a great question. I didn't draft the title or the language, and I will say the point that is important is it has to be a substantial, real, demonstrable risk. How you might differentiate that from extreme may be some degrees, but it can't be something remotely trivial that we're talking about here. It's got to be something that is meaningful, substantial. Yes?
Yeah, so I like the bill, and I'm sure everybody here will think, whoa, and I guess I'm going to be photographed. And I took myself at risk, I think, in this community by doing that. I have a PhD in human development. I've been a university professor since 1974. I'm a licensed marriage and family therapist in the state of Colorado. I was director of the Student Counseling Center at CSU Belleville for 10 years. I'm an adjunct faculty. I'm teaching a course in abnormal psychology and trauma. I think the law is appropriate. I have worked with law enforcement when I was director of the Student Counseling Center. We had students who needed to be placed in 72-hour hold. The people I worked with in the Sheriff's Department in Buffalo were well trained. They had adequate protocols. We didn't take their student to the hospital, to Parkview. Law enforcement did. They treated students respectfully. And the people at Parkview, I think, did a good job of basically determining whether that person should be held or not. And I know some people said, well, they weren't held. I've heard that before. So, you know, it's kind of like somewhere along the line, you've got to trust people. And I trust law enforcement. I've had good experiences with our local law enforcement. And I think the bill is appropriate because there are people who are going to be a danger to themselves or others if they have a firearm. And I think the program you're talking about is reasonable, and there's a way to refine it if it's not working. So personally, I'm in favor of that, and I don't speak for the organization, just for myself.
Well, I want to say how much I respect both of you, Bob, and your name again was?
Mine?
Yeah.
Timmy.
Say it again?
Timmy.
Timmy. Timmy, I got it, Timmy. So Bob and Timmy, your points are heartfelt, they're principled, they're thoughtful. The concern about false positives, it's a real one. I want us to get this right, and part of what I have that leads me, just like the gentleman who just spoke, is confidence in law enforcement to operate in a way, and I'll use this word with the deepest meaning, integrity, which means working hard to get the facts right. The moment we're now in, I just want to acknowledge there's a lot of people who will take shots at law enforcement, at police officers. There's not as much, let's say, systematic respect for the rule of law and law enforcement as I'd like to see. So I want us to work with law enforcement. There are some bad apples. One law we just passed this term, by the way. If you're a law enforcement official and you lie under oath, you lose your ability to be a law enforcement official, and that's appropriate. But what you have here in Chief Harvey and the standard of integrity that he represents is exactly what we're talking about here, doing the work carefully, thoughtfully, and responsibly. And that is so important to the future of our society. Do we have a final question or thoughts someone wants to share?
I'm kind of confused.
Sure.
I was also a college person. I'm sorry, that's not. My dad was a college person. But, let's see if I can figure out how to say this. You're saying that in this bill that a police officer can confiscate a gun if they go into a situation and they think that there is a mental illness or a mental health problem before they go to a judge. And then they go to a judge, and the judge says yes or no?
No, let me say it again.
Okay.
Thank you for asking. The only way the weapon is authorized to be removed is when a judge makes that authorization.
Okay.
Before the judge would make an authorization, a law enforcement official would come before the judge with evidence. So the way this would work is your police chief or your county sheriff or wherever you are would get a report. We think this person is a risk, substantial risk to, or significant risk to himself or herself or others. That gets investigated, and there has to be enough evidence so that it's more likely than not that the person is posing that risk. And if the judge concludes the evidence is there, the judge would then authorize the weapon to be removed temporarily before there'd be the real deal, which is the hearing. And the hearing would have the person whose weapon is at issue at the hearing. That person would get a lawyer paid for by the state and would get a chance to put on his or her own evidence and to undermine any claims made against him or her. And the standard that would have to be established is clear and convincing evidence. And only in that situation would the weapon be able to be removed up to 365 days.
I appreciate you clarifying that, because a lot of people think that a policeman or a sheriff can just walk in and confiscate your weapons. And
So,
there's a difference there.
I should let your police chief talk about the practice, but if you are suspected of being involved in a crime,
Right.
but if there's no criminal question, this is the only tool to remove a weapon, and this is technically a civil action. It's not a criminal action, but it's managed by law enforcement. The first step is to have to go before a judge to get the authorization. Now, to be clear, again, the fancy legal word is Latin, is ex parte, which means the procedure before the judge is only one party. You don't have both parties there, but still, the judge is an independent decision maker and has to decide that it was more likely than not that this person is a significant risk to himself or others. Tim, you want to make a point on that?
Just one last question, and dovetailing on what you said for clarification. So, say for instance, Chief Harvey or Sheriff Cooper rolls up on a situation, okay? And you said follow the facts, follow the evidence.
Yeah.
So for me, coming from a clinical situation and looking at this, and then taking this evidence as facts going before a judge is what I'm thinking the process is. Is that
Yeah.
correct?
Yeah.
Okay. So am I understanding this correctly? Then they roll up on a situation, and the person is someone that maybe they think they should arrest or do whatever with. Will that person have the benefit of getting a mental health evaluation prior to being adjudicated, either not safe to have this gun or to be saying they're good to go? Because if they don't, I think that's a violation of their right.
So this is some of the issues we're going to work on in the implementation, to figure out how to do this. I believe the law is silent on this issue, but what I would say is we should work towards what best practice looks like. And I will say the person has the right, as part of their defense, if you will, to submit a mental health evaluation. Whether or not law enforcement would have the burden of necessarily showing one is a really good question. We should look at it, and your police chief is widely respected in the state. And so whatever issue, this or other ones, that you have views on state criminal justice policy, talk to your police chief about. And Bob Booth, who's here with me, we're going to work with the Peace Officer Standards and Training Program to help develop the right protocols. This input is important. And I just want to say, before this law got passed, I had people in my office who were skeptics of it sharing their concerns so we could think about them. Now that it's passed, I want to hear from skeptics so as we look at what the right practice is to implement it the best way we can, even if there are concerns of the types you're mentioning. I want to let this individual get the last question here.
Well, you answered my question a little bit earlier about the 72-hour hold and all. As Bob says, it works quite often. And I think that's a good thing, which to me makes this law a little bit superfluous. But on top of that, when I ask about a person having to come in, he might be a truck driver, be working, he has to come in and defend himself. Not against a crime, not against anything illegal, but he's having to come in because somebody just said he might be doing something. So you're basically withholding the rights of a person who's only accused of maybe possibly doing something that could be happening in the future. That's kind of vague.
Thought crime.
So I would say there is this initial burden that the law enforcement has to show, which is it's more likely than not. So it's not nothing. But to your point,
It's not a crime.
they have not committed a crime. You're right. The legal system does this a lot on people. If you're a witness in a civil case, you can be hauled into court to be a witness, and you don't get reimbursed for that. So I recognize your point. It is a burden on people to have to be subject to the legal system, and we have to figure out how to craft the legal system that's least intrusive on people, because it is an intrusion with the goal of keeping us safe as a society.
And I've worked in the legal, I'm a retired correctional officer.
Yep.
And I've just seen how the laws have been used to sometimes drag things in a ridiculous manner. And I think this one opens up a lot of possibilities for abuse, like maybe perhaps a wife that didn't do her child support properly.
Well, when
Yeah.
I come back and we do another one of these some point, this law may have been upheld and constitutional, may be in effect, and we'll be able to look at actual cases. I do think this is the challenge, and it's not only in this context, but in lots of contexts. How do you limit false positives where things are being done in a way that are wrong? And then how do you limit false negatives when you don't do things that you should have done? And that's a challenge for the legal system, and I take that challenge very seriously. All right, we've got
I just have a quick question.
2 more. Yeah, go for it.
On the same subject, do you get to face your accuser in this whole scenario?
So there is this hearing, and then the question that, again, to put the fine point on it, in the hearing, is the person who's giving information for law enforcement have to be there? I don't believe that's required in the law. Now, the law enforcement agency who's petitioning has to make a judgment, which is how do they get their evidence, and it may be in the form of that person testifying. So that's not going to, I believe, be required, but it may well happen in many cases.
Sir, just one last comment.
Sure.
I'm a professional, and I respect the integrity of the profession that I'm representing here today, sir. And that means that we're working very hard clinically across the United States to give people, whether they're veterans or any walk of life, to say, it's okay to say, I have a problem.
Right.
It's okay to go and see somebody clinically. Putting this kind of a situation into the mix is certainly anxiety producing. Somebody that may want to go will say, well, hey, can they go check and see if I've seen this clinician? And then it opens up another can of worms also for the clinician to be pulled in there. And it also opens up a can of worms for one clinician to be played against another, because one says this person is mentally healthy, another says they're not. So where's the person that's being evaluated at in the middle of this? You see what I'm saying?
Yeah. I will say one point to your point that we have to work on, and let me broaden it, not just mental illness, but substance abuse. We've got to work on destigmatizing. All of us know people who are mentally ill. All of us know people who are abusing substances, and these are people that deserve our compassion. All right, we've got 2 last people. Let me give them to you, then I want to let people go. Yeah, you, sir, and then you, sir.
One quick point. If this law is so great, how come over half the counties in the state have come out and said they would not enforce it?
There is an argument, we heard Bob make it, that this law is unconstitutional, and that argument is one that as many counties that want to make it have the right to make it. And our legal system allows for those challenges. That's part of the way we live, and we should celebrate that we live in a country that allows for that to happen. There are other places that don't have this system of the rule of law, and you've got one person leading, and the law is whatever the leader says.
Tommy, Jimmy brought up something that really I hadn't considered, and it's the possibility that this law could cause people to not seek help when they need it. And that's something we should take
I agree.
into consideration.
I don't want that effect. I'm less concerned about that, because the truth is, if you're mentally ill and you get help, you're more likely to be in a position that you're not a threat to yourself or others. And people who are mentally ill, the sooner they can get help, the better they're going to be. All right, last question.
I'm I see in this whole thing just really a can of worms, a legal can of worms, and a lack of due process. That the individual, like if I'm somebody raps on me and says, "Well, I think he's going to do this," or "I think he's going to do that," and they're angry at me over something, or have an issue with me over something, and they go to the police or the sheriff, and where's my due process in this whole thing? I mean,
Let me just give you an answer, and here's what I want to say as you guys think about your constitutional challenges that you may or may not be a part of. This procedure we're talking about is identical to the procedure used to remove your kids from you. Okay? If you want to argue this law is unconstitutional because it violates due process, my only request is similar laws that have similar impacts need to also be classed as unconstitutional as violating due process. That's all I ask. Whether, if you have a due process challenge, you need to challenge all procedures that have the same features, because the abuse and neglect procedure for moving your kids is the same one that we're talking about here. And if people think that procedure is unconstitutional too, then I'll have to tell you, we've got a lot of other procedures that we're going to be looking at about how we fix them. And if the courts say that's what we need to do, that's what I'll work on doing. And I just want to thank you all for being engaged citizens. This is really important. And just like Bob said, we can disagree, but do it in a way that's not disagreeable. And I look forward to, if I can earn it, occasionally getting attaboy from your committee. And in the meantime, I'll be happy to keep coming back and getting thoughts and feedback. Thank you all for being here. Really appreciate it. Okay, one last one.
Really fast. I read the bill. Doesn't it state, and perhaps I'm wrong, it's not like your neighbor can call or somebody.
Let me just talk to you. Yeah.
You have to be residing with the person, correct?
Well, I'll get something. I mean, I'll be right behind you. Where'd you walk? I haven't seen one yet. I haven't seen one of those. Oh, I got one.